Okay, so another area of intellectual property law that I want to address is copyright law. So we know that trademark law protects items that help define a company brand, such as its logo, slogan, colors. But copyright law, on the other hand, is geared more toward literary or artistic works, such as books, websites, videos, these sorts of things. So it's a little bit different, but it's still a protection of original work, right? So same premise exists at the core here. And copyright law does grant exclusive rights to anyone that creates some kind of original work. So similar to trademark law in that capacity. And typically with copyright law, once a copyright owner has protection of their original work, they have that protection for a long period of time. But as I mentioned at the top of our conversation today, at some point those protections go away, right? There are limits to how long someone can own a copyright of their original work. So eventually what we see is this public domain, right, where copyright expires and the public that piece of work then goes out into the public domain. So essentially, when we think about copyright law, there are a couple of different sets of rights, right? The creator who has developed the original work, and then the owner, right? That's the person or organization that owns that work and then is able to use it or generate revenue off of it. Okay, so what are the laws here regarding copyright law? So the big one here in the US is the Copyright Act of 1976. This is our primary federal law on copyright. So you can, I won't read through it, but you can see the various categories of works that are protected under copyright law, right? And some of these may not be as relevant to us in KNR, but I think it is important to note that when we talk about copyright law, over time, obviously as technology changes, there have been other types of original work that are protected under copyright law. So one that might be relevant to us, especially those of you going into sport, would be the broadcasts of live sporting events. So this law has been amended to include that. So anytime a broadcasting network records and puts out live sporting events, that is considered copyright protectable under the Copyright Act of 1976. So sometimes if you're listening or watching sports on TV, you probably hear them address their copyright law rights, right? Their legal rights to that broadcast, meaning that technically it's illegal for someone to reproduce or share that footage because they own it. One thing to note that in terms of copyright law, generally the courts have said that sequences of exercise or movements are not covered under the Copyright Act of 1976. This one's kind of relevant to those of you that might want to go on to the fitness or exercise side of things. So here's an example, excuse me, an example case. Some of you might be familiar with this gentleman. His name's Bikram Choudhury. He is the original creator of the hot yoga concept. And this is a really interesting precedent-setting case in copyright law because basically after he developed this idea of hot yoga, yoga studios all over the country started using it, right, and selling classes to hot yoga. And basically what his reaction was, hey, this is something I came up with. It's an original creation of mine. Therefore, I own the copyright and I don't think anyone else should be able to use it without paying me some kind of fee. So he went to court over it, basically suing some of these yoga studios that were using the method. And the court said, you know what, copyright only protects the expression of this idea that he had. So the words and pictures used to describe the sequence could be protected, but not the idea itself. Right? So if he wrote a book, which I believe he did eventually, that described the sequences and there were visuals and photos of that, that's something he could protect under copyright law. But the actual sequences themselves, the concept, the idea, could not be protected. So that, again, this is kind of a precedent-setting case in that it really set a standard for what is actually protectable under this Copyright Act of 1976 when it comes to exercise or movement. Okay, so just like with trademark registration, it is possible for a company to file for copyright registration. Generally, a copyright exists as soon as a work is created and put into tangible form, right? If we go back to the last example case again, if Bikram puts his ideas into some kind of tangible form, whether it's through a book or a website, then the copyright is in existence. You can file for federal registration. You can see here we have a specific office in the U.S. government that looks at these and approves or disapproves. So again, unlike trademark law where you could file for state registration, copyright law is only at the federal level. So anytime you see the C with a circle around it, I pulled this from the Four Seasons website, that indicates copyright protection. Okay, so in order to be protected or to get that approval of registration, copyrights have to meet two requirements. First and foremost, they have to be original, right? It has to be a new idea or concept, otherwise it's not going to be protected under copyright. Second, this concept of fixation, right? So basically the idea itself has to be put into tangible form in order for it to be protected. It can't just be living in your head. As evidenced through the Bikram yoga case. So as long as you've taken that idea, written it down, or recorded it, then it can be protected under copyright law. So if we think about the sport example, a live sporting event itself isn't something tangible, right? It's an experience. However, if the game is actually recorded and then broadcast or otherwise put into tangible form, then the fixed form of that game becomes copyrightable. Hopefully that makes sense. Okay, when it comes to an existing copyright, once it's registered and protected, copyrights can be transferred or sold. So someone, let's say like a big musician, popular musician who owns the rights to their music, they can sell those rights or they can transfer them to, let's say, their wife or husband or spouse, or their children. So copyrights can be transferred from one person to another. I think that's an important thing to note. A lot of times you will see joint work in reference to copyright, right? 2 or 3 people might work together on developing a logo and a slogan for, a park district. They would be considered co-owners of that copyright because both or multiple parties worked on it. One thing that I think is important for you to be aware of as future K&R practitioners is that, unfortunately, any work that you do for your employer in this area is generally owned by that employer, right? So let's say that you develop a logo for the K&R site that you work for. You file for copyright protection for the organization. You file for copyright protection and all of that. 5 years later, you leave that organization. Guess what? Your employer owns that copyright, not you. That's generally the policy, unless you've somehow specified in a contract that you want to have ownership of that copyright. Generally, the way that these organizations are set up, they would maintain ownership of that copyright long after you leave that organization. Okay, so what does copyright infringement look like? So similar to trademark infringement, right? It occurs when someone makes an unauthorized use of copyrighted work. So there are a couple of elements here that have to be proven by the copyright owner. And again, similar to trademark, it really is up to the copyright owner to keep tabs on this kind of thing to make sure that their work isn't being used by another organization or person. So 2 elements here, basically. The first is they have to be able to show ownership of that valid copyright, right? Again, pretty straightforward there, just proof that they own that copyright and that it's been registered. Second, they have to show that copying of elements of the work are original, right? So a couple things here have to be true in order for this to be proven, right? The defendant actually had to have access to the work, right? So they had to, at some point, be exposed to whatever the copyright was, the tangible product. And then 2, the work has to be considered to be strikingly similar, right? So similar again to what we looked at with trademark law, there has to be some kind of consumer confusion here in that the work has to be very similar. So if those elements can be proven, you can prove copyright infringement. All right, last thing I want to talk about here is this right of publicity. So this really does two things. Basically, it gives athletes, celebrities, the right to make money off of their image, right? And it makes it illegal for others to do so without getting their permission first, right? That's basically what we're talking about here when we talk about right of publicity. You might remember some of our conversations earlier in the semester on privacy. We talked about this concept of appropriation, right? So basically, if someone's image or likeness is used for profit without their permission, they can file for an invasion of privacy lawsuit under this concept of appropriation. So, there basically is no federal law protection here regarding right of publicity, but states generally have common law protections. Plus, there are some specific laws regarding appropriation. Basically, athletes, in general, have a right to control and profit off their names and likenesses. And I will say historically that means professional athletes, right? That doesn't include college athletes, although we'll talk about some changes in that area on the next few slides. Basically, anything that evokes their marketable identity is protected under this concept of right of publicity. Now, there are some limitations to this protection, right? Again, back to this idea of free speech, which we're familiar with from our conversations on constitutional law. Again, news organizations, websites have the right to utilize player information, images, if the purpose is to inform the public, right? So if they're doing so to exercise their right of free speech, particularly free press, then they are allowed to do that without having to worry about being sued by that individual or organization. Okay, really quick summary here on our IP law unit. I know we covered a lot of ground here in a fairly short amount of time, but in summary, I want you to be able to define and discern between the different types of IP law that we looked at today, right? So make sure you know the difference between trademark, copyright, and right of publicity. Make sure you're aware of the various registration processes and ways that K&R organizations can go about protecting their IP. And then finally, probably the biggest takeaway from this unit for you should be that you can apply those key elements for a trademark infringement lawsuit.